Well, good evening, everybody, and welcome to the Inner Temple and to this international panel discussion on putting the case or challenging the truth, effective cross-examination in international trials and arbitrations. For those of you who don't know me, I'm Richard Salter. I'm Treasurer of the Inn this year. I'm essentially a finance lawyer, so I'm slightly outnumbered at the moment by having two criminal lawyers on either side of me. We will hope shortly be joined by a construction lawyer, so you'll have a variety of people in the panel. I must begin with some housekeeping. First of all, welcome to those online as well as those in the room. This event is being recorded and will appear on Inner Temple channels in the coming week. Can I ask those of you who are in the room to make sure that your mobile telephones are all switched off or muted in some other way? And may I remind those in the room that students and those requiring a qualifying session credit must sign the sheet in the reception area before leaving, or you won't get your credit. Those attending online will automatically be recorded. Practicing barristers can keep their own note for their CPD records. And I should say that for those who are not Inner Temple students, this event is not a qualifying session. Let me talk a little bit about the format. We're going to start off with three presentations. A presentation by Stephen Kay on cross-examination for an international tribunal from the point of view of a common lawyer, followed by a presentation from Dr. Leonie von Braun on cross-examination for an international tribunal from the point of view of a civil lawyer, and then Jane Davies Evans is going to talk about cross-examination in front of international arbitration panels. Different perspectives on the matter. Each presentation will last about 15 minutes. When that's finished, we're then going to move to the case studies. You should all have copies of the case studies available to you. And I'm going to take the case studies in order. First of all, ask each person about their individual case study and to remind us what the interesting issues of that are. And then we'll invite some questions from the audience. And not merely questions from those in the room, who will need the roving mic so that everybody can hear you, including those online. But questions online, the online questions will come in on this little laptop, and then I will ask them of the relevant people. And we hope to get some kind of lively debate going during that. Let's start, if we may, by inviting Stephen Kay to give his presentation. Let me tell you a little bit about Stephen. Stephen KKC is the head of 9 BR Chambers. He's a leading international criminal lawyer who has been in the landmark cases that have established modern international criminal law, including the first UN trial of the Yugoslavia Tribunal, the first trial of a former head of state, the ex-president of Serbia, Slobodan Milosevic, the first trial at the ICC of an incumbent head of state, President Uhuru Kenyatta of Kenya. And Stephen's career has involved cases in the international courts, but he's also engaged by individuals, governments, and organizations to advise and represent them when they face a crisis and need to challenge matters of national and international concern. Stephen's international fraud, bribery, and corruption practice has included cases of global interest and are often multi-jurisdictional. Stephen's other international areas of practice include international human rights, sanctions, and Interpol Red Notice. I'm pleased to say he's a governing bencher at the Inner Temple. Stephen, over to you.
Thank you, Richard, and thank you to the Inner Temple for inviting me to speak tonight. And it's very interesting to get the perspective from a common lawyer of cross-examination and a lawyer from the Civil Code and their perspective in respect of cross-examination, because the international courts thrive between both sectors and the judges apply their experience as well as their understanding of other codes other than their own. And so these cases are kind of hybrid cases in terms of their law. So this evening I'm taking an example from a real case. It was the case of General Cermak, which was heard at the Yugoslavia Tribunal. I put on my sheet a link to a YouTube clip which shows part of the cross-examination of the military expert for the prosecution in that case. And within that short clip of 5 minutes or so, the issues relating to command and control, very important in the context of a military command case, were aired, and essentially the indictment collapsed before the eyes of the prosecution. So just to introduce the Cermak case, General Cermak, who was the defendant in that case, was charged with war crimes arising from the operation by the Croatian forces to liberate their lands that had been occupied by Serbian forces in what was called Operation Allure. And it was alleged that war crimes were caused by the split military district against the civilian population, the Serbian, ethnic Serbian population that occupied those lands. So the prosecution built their case against Cermak on the basis that he was the garrison commander of Knin, and according to their interpretation of the military regulations, had control over the forces in the district of Knin, where it was alleged that Serbian villagers and villagers were attacked, murdered, and their houses and property destroyed. Prosecution called witnesses involving Serbian witnesses from those villages, so civilians. They called UN senior military personnel. They also called witnesses from the Croatian forces, who they asked to give an explanation as to what had happened and how the operations took place. And within their evidence, they called a military expert. There were other experts as well, political experts, etc. So for the defense, we called an expert who was a former general of the British Army, General Sir Jack Deverill. We called a former commander, Deputy Chief Constable of the Ulster Police Force, Chris Olberston, and we also called a general from the Croatian forces, General Feldi, and he was the man who'd actually drafted the military regulations many years before. And amongst our witnesses, we called political witnesses from the local community, as well as some Serbian villagers. So the court had before them a balance on both sides of two competing narratives in relation to what had happened. But the prosecution case against Cermak hung upon this point that he had command and control in relation to the area around Knin, and that he was a senior colonel general appointed by Franjo Tuđman, the president of Croatia, and was a supreme commander of the area. So, cross-examination in respect of witnesses in this type of case is all about preparation. Preparation is the key before any cross-examination in a case of this nature. The prosecution had filed a very detailed military experts report, as well as other reports, and called witnesses, had film evidence, and spent their time building this case that Cermak had command and control. And their evidence was backed up by the UN forces. So a British intelligence officer gave evidence and was happy to point the finger at General Cermak and said he had control of the forces involving the attacks upon the Serbs. Now, in these kinds of cases, they are highly politically charged. Crimes that have been committed have been very serious. Mass deaths, mass tortures, mass burnings and pillaging. And so people tend to take sides. Even professional people get there to a courtroom and think that they are doing good by helping one side or the other. And I mentioned that in the case of the British intelligence officer who rather surprised me with his allegations concerning the limited amount of knowledge he had of the running of the Croatian forces. So preparation being the key, we instructed our experts, as I said, General Deverill, former Assistant Chief Constable Chris Olberston, and General Feldy. And the first place that we started at was the orders. What were the prosecution relying upon? And they had in the experts' report a series of orders. These cases are document heavy. They probably had, I would say, about 1,000 orders because it was a joint case involving 3 generals. Next thing that we did was go to Croatia and seek to look at the military structure and how it worked, which is why we interviewed General Feldy. And it turned out that he had drafted the regulations for how the Croatian army should be structured, and indeed the powers and authority of the garrison commander, otherwise known as the Zbornomajstra. So in his regulations, there were aspects that showed that there was indeed control over military forces, but that control related only to the garrison. So the issue became, what does a garrison commander do? And if you look at the regulations, he deals with the running of the town for the troops, when they've got to be home, when they're allowed out, what they do and how they spend their time. So because of the issues surrounding these sorts of cases, when you're calling one side and the general from one side giving evidence exonerating someone from his side, we found General Sir Jack Deverill, who's a very experienced UK commander. He'd been in Bosnia, he'd commanded British forces in Afghanistan. And you wouldn't have thought he was the likely source of witness for the defence. There is indeed a reluctance for people to engage for the defence in these cases. So we presented the outline of our case to him. How we said it was structured by the prosecution with full and transparent disclosure, and what we said was wrong with it, and indeed the briefings that General Feldy had given us. And at the end of that presentation, he said, well, I know a garrison commander. We have them in the UK Army. And General Feldy is right. And then he spent a number of months preparing a report outlining what a garrison commander's role is, as well as analysing the so-called orders that the prosecution were relying upon. As part of this preparation, we looked at the types of orders, and that included General Cermak requesting permission from the genuine military commander, General Gotovina, for permission to provide prosciutto to some journalists who had come to visit Canine and report on the situation there. So gradually, researching the archives, we put together a number of very key documents that reverse the prosecution case theory. The clip that you've got on that sheet, and which may have been sent to you by email as well, and you can just click on the link, has an aspect of that cross-examination. The first question I asked is about a document which relates to the appointment of General Cermak. It was the 5th of August. Now, the 5th of August was the day after Operation Allure had started. And the appointment was by the president, Franjo Tuđman. It wasn't within the military system. So it was established that Cermak was nothing to do with the planning of Operation Allure. He hadn't been at an island called Leonie where it was planned. He hadn't been appointed within the military system. So why then was the president appointing him? Prosecution were putting Franjo Tuđman is a war criminal, and this was his way of appointing his man, his general, to the area to carry out his orders and instructions for ethnic cleansing. That simply wasn't the case. He was put in there as well because there was a humanitarian crisis in Knin once the Croatian troops went into the district and they had to deal with a war-torn area, the water bombed, electricity bombed, no food, kind of thing that we're experiencing in Gaza at the moment. And actually, the background to this case was that Cermak was sent there because he was a very clever businessman, very good at logistics. He ran an oil company, and he was there to try and get the area properly running back to normal and safeguard the civilian population, particularly in Knin. And that was why he was given this role of the garrison commander. So the questioning that I had to put to the prosecution expert witness was all upon this issue of command and control. What does the evidence say? And the problem with these cases is that once they're launched in an international court, you really do get something called confirmation bias. People take sides. They see only what they want to see. And that was so in this case. Quite frankly, the prosecution case collapsed after that military expert because I put to him the key section of the indictment alleging Cermak's control of the forces. And if you look at the clip carefully, you'll see the actual general Gotovina laughing, looking at Cermak, the man next to him, and laughing and pointing, looking to the crowd where he's got supporters and saying, that's him over there. Quite frankly, the case disappeared and collapsed. So very, very important in these cases is that preparation and being able to put your documents, your narrative, your challenge to the prosecution case and make sure it is in a completely coherent and understandable way. Now, one of the points I want to make as well in relation to the presentation of these cases, they are document heavy. You have to be very, very organised. They're all filmed. They're live trials. They're on TV. People were watching this cross-examination in Croatia as well as cross-examination of the other witnesses. And you've got to be organised and prepared. So my passing tip to young lawyers looking at practicing in this area, you've really got to make sure you are on top of your subject. I think I've done my 15 minutes now exactly, Richard, but I will stop here.
Thank you very much, Stephen. That was very interesting. Can I just, before we move on, ask you this question? Who were the members of the tribunal whom you were cross-examining before?
Yes, presiding judge was Judge Ori, who had been in the case of Tadic with me as my fellow counsel, which was the first UN trial case, and the issue was raised as to our connection before the trial started, but the prosecutor waived any objection that we had any personal interest. And then there were two other judges, one from Zimbabwe and another judge from Estonia. So you've got a real mix of traditions there. You had Zimbabwe, you had Dutch civil, and then you had Estonia, Romano-Dutch, I think, with a bit of Russian thrown in. So you had a very complicated mix of people. And as well, language. Your judge may not be a native English speaker. So you'll notice in the clip, one of the things I wanted to point out was you speak slowly because there is a simultaneous translation. There is a note on the screen. You've got to make sure when you're asking the question that the interpreter has understood you correctly. And then you've got to make sure that everybody has time to digest it into their language. So you speak at half the pace I'm speaking today, but you get your message across in that time. And you have good thinking time that way, I always find, so I don't mind.
The trouble is it gives the witness thinking time too. Right, now it's the turn of Dr. Leonie von Braun. Leonie is a German prosecutor and senior trial lawyer at the Office of the Prosecutor of the ICC in The Hague. She studied law in Bonn and Berlin until 2003, after which she completed a doctoral thesis in international criminal law. In 2009, she entered the judiciary in the state of Bonn, first working as a judge and then transitioning to the prosecution team. Her area of focus became organized crime, with a focus on human trafficking cases. Leonie joined the Officer of the Prosecutor at the ICC in the summer of 2018 as a trial lawyer, and in May 2023 became a senior trial lawyer there. Leonie, over to you.
Thank you very much. And good evening to you all here in the room and online. Thank you for having me here tonight and spending your time with me. It's a true pleasure. It's my first time that I'm visiting the Inner Temple. It's already been a wonderful day, and I've learned so much. So looking forward to the rest of the evening also with you all. I've been asked to speak briefly to you about cross-examination at the International Criminal Court from an inquisitorial perspective, or the perspective of a lawyer trained in the civil law tradition. In particular, what are the challenges for someone like me appearing before a chamber at the ICC who is in majority or maybe even completely from common law traditions? So as Stephen K. just said, you will have a diverse set of judges often on panels, but it can happen also that the majority, or at least the presiding judge, is from a common law tradition. In addressing these issues with you tonight, I do want to avoid being overly stereotypical, because in fact, the different traditions, common law and civil law, I find that they have more in common than we often think the difference may be. At the ICC, we all come together and we make it work somehow. We have our own hybrid system that incorporates the basic principles of a functioning criminal system. It is hybrid with a mix in the details. But strangely enough, it may be a unique outcome in practice, but it works. So if I highlight some differences this evening, they are meant to maybe amplify and explain some things, but I hope that they do not come across as too stereotypical for you. Nonetheless, it is important to note that the culture shock for a civil trained lawyer like myself at the ICC is a real thing, yeah? The reason is that at the ICC, you have a model that at trial follows a common law tradition, a common law setup, with the prosecution bringing its case, and then the defense, if they so choose, bringing their counter case. Witnesses and other evidence are brought in by the prosecution first, and then from the defense. The calling party, in practice, has the right to examine first, and then there is the right to cross-examine. You could say that for that cross-examination for civil law lawyers like myself at the ICC is actually, and at the beginning at least I felt like this often, is like dancing the tango, but all you've learned is dancing the waltz. Now, at the ICC, knowing how to dance the waltz can get you where you want to get. But in practice, sometimes you are expected to tango, and it's not so good to learn while you're doing it. Training is important, and I'll give some insight into how I tried to make it work and who helped me with that a bit later on in the end of my presentation. Why does it help that you at least know how to waltz? Because the tradition I come from is the center principle is more the truth-finding and fact-finding objective, both for the prosecutor as well as the chamber dealing with a case. These same principles are enshrined in the Rome Statute and the Rules of Procedure and Evidence. So also at the ICC, the prosecution is obligated to investigate exonerating and incriminating evidence equally. This is a core principle of the mandate of a prosecutor in Germany as well. We are objective from the start as we lead investigations. So there are a lot of similarities that a civil law trained person like myself can relate to. However, what are examples of common law concepts that have confused me when I started at the ICC? And I'm just going to name a few so I don't overstep my time too much. So the notion that the prosecution brings a case is already confusing. Witnesses can get proofed before testifying, also confusing. Judges basically take a step back and the parties do the work. Also new. The notion that you should be persuasive even though you're only examining a witness for fact-finding purposes. And what does it even mean to put your case? So to understand why these notions can be confusing to someone like me, I want to take you into what are some basic principles of the civil law tradition, and then how does it work at the ICC? So cross-examination, especially, our subject for tonight, is, as it is practiced here in the UK and in other common law traditions, which are also all not homogeneous, as I've learned, that doesn't exist as a phenomenon per se in a jurisdiction like Germany. It does not mean, though, that the court, the prosecution, the defense do not probe the credibility, reliability, and authenticity of evidence rigorously. It's just how it's done is different. So we focus more on truth-seeking and primarily through the judge at trial. So it's less about persuasion and dramatic confrontation. In a jurisdiction like Germany, the prosecution heads the investigation as objectively as possible, then charges, and then the case gets handed over to the chamber. Basically, the chamber has complete control. So the judges decide in which order witnesses are called, or other evidence is included on the record. The prosecution then acts as a check. Questioning is directed by the presiding judge, first and foremost, in an open way. So who, when, what, where. In a second layer, traditionally, the presiding judge will have follow-up questions, and only in the third instance can it get confrontational. For instance, the line of questioning has identified inconsistencies within the witness's own testimony, or prior recorded testimony is at odds with the testimony at trial. This third layer is very similar to cross-examination known in common law situation. However, it is done in a different setting and by a different actor in the first instance. Only after the judge is done, in his or her opinion, is it the prosecution's time to ask. And ideally, the judge will have done all he or she can to clarify the relevant facts that are relevant for the indictment. This is, of course, in practice, not always the case. So, as in a common law jurisdiction, the prosecutor, like myself in Berlin then, I can't sit there and go to sleep. Yeah? I have to be just as prepared as the judge. I have to follow closely, because in the end, even though the case is handed over to the court, I have only indicted this person because I believe there's enough evidence for a conviction. So sitting back and saying it's out of my hands is also not the reality of the job. So preparation, just like Stephen Kay just said in his example, is the key for an effective prosecution also in a civil law jurisdiction. Sometimes you have to pick up the pieces of, that a judge has left behind. And luckily, this role is respected in the courtroom, so the chamber will have to accept that the prosecution may actually start from the beginning again if important facts have not been addressed by the chamber. So we do things differently, but actually it leads to similar outcomes. And there are enough similarities that even a civil law trained lawyer can at least survive in front of a common law chamber that has different expectations, perhaps. Yes, but of course, we do not endeavor to destroy the other side's case, yeah, because there is no other side's case. We don't ask leading questions, yeah, or only in the third instance after the open narrative and the fact-finding has not led in the right direction. Leading questions are only allowed in very limited circumstances. And cross-examination as a concept in its own right, as practiced here, just does not exist. So the difference in the systems, I want to say, though, also does impact on advocacy styles. Yeah, that is a real issue, I would say. So a common law lawyer, and again, I hope I'm not coming across too stereotypical, but this is really my impression also of colleagues I'm working with. They are trained in a completely different way that I get trained at home in my jurisdiction. So there is emphasis on, confident, eloquent speaking, use of language, even body language, use of pauses, etc. This type of emphasis in training, at least in Germany, I did not receive that. So maybe there are other civil law jurisdictions where there's more emphasis on it, but definitely not. So it's a bit of a learning curve there as well. So I often think that I'm more trained in like forensic modesty rather than, being being overly persuasive and knowing how to get my point across. But yeah. Luckily, appearing before the ICC, I quickly found that it can be everybody's nightmare, not just German prosecutors. And the reason for that is that we have a mixed system. Yeah. So, for instance, evidence is submitted, not admitted. Judges may intervene at any time, and colleagues from civil law jurisdictions do that vigorously. Judges may also call their own evidence. So at the moment in practice, it is the case that we have the order of the prosecution goes first and then the defense comes. But in fact, Rule 140 of the rules, which I stumbled across in preparing for tonight, actually would give a judge the right to question first. So it's very interesting. Maybe I shouldn't say it too loud, but I'm just saying. So this I have seen in practice. Of course, you will find some judges intervene more than others, and oftentimes it is the judges from civil law jurisdictions that tend to, grab the mic rather than their colleagues from a common law jurisdiction. And that has and can fluster colleagues from a common law background, maybe sometimes more than a colleague from a civil law jurisdiction. Especially if a judge goes as far as saying, well, I'd rather like this line of inquiry even, and your entire strategy goes off the rails, and you end up having to decide, do I fight with the judge about that this is my witness and my time, or do I take a moment and see how do I make both scenarios work? Yeah, so those are challenges that we all face sometimes, independent of our background. Yeah. So with all this in mind, now you can imagine that when a civil law prosecutor like myself meets a common law presiding judge before the ICC, it can generally work quite well when we are talking about the direct examination of witnesses, very open questions, no hesitation for open narrative. While you know where you want to go, you are very well prepared because it's what you've learned to do from the get-go in your own jurisdiction. But it all can go awry when it goes in the direction of when you're asked to cross-examine. So it may be that their civil lawyers do need a bit more training and a bit more dialogue with their colleagues from common law traditions, and I've been fortunate to have that. And I've also sought that to overcome my own unawareness of phenomena like having to put your case. So at least even if I don't choose to do it, and there is no rule that you have to at the ICC, but even if you decide strategically that for this or this situation it's not necessary, it is important to know how to do it. So in the general sense. So I'll leave it at that for now, and I'm happy to answer any more questions that come up.
Leonie, that's very kind. Thank you very much for that. Can I ask you the same question I asked Stephen? Who are the judges at the ICC? What is the panel before whom you're appearing?
Yeah, well, currently one of the panels I'm appearing before is a very diverse bench as well. So the presiding judge is from a common law jurisdiction. And the others are, one is from a civil law, and the third is, I don't actually know. I think they have more of a hybrid system. The first trial I was involved in, the presiding judge was also common law, and had very high expectations on not to use leading questions in direct examination, which luckily I avoided most of the time. But she was very strict about it. Yeah. Yeah.
Yes, it's an interesting contrast. You talk about not using body language and not using pauses and things like this. Of course, you're trying to persuade your tribunal, aren't you? You're trying to get them, and your judges come from different traditions. In particular, criminal judges in England are used to sitting with a jury. So they are not the deciders of fact. And baby judges, I remember it well, when you go to the judicial college, are taught, don't ask questions, don't intervene, because the jury will pay more attention to the questions that you ask than they will to counsel's. You will be influencing them unnecessarily, and so you shouldn't do it. Whereas if you sit mostly in civil, you are the sole tribunal of fact, and the judges in commercial cases are much more ready to intervene. Interesting you should talk about, do you follow the line of questioning the judge wants to go down, or the argument. It's a story told about James Mackay, who was our Lord Chancellor, but he was the Lord Advocate for Scotland, and was appearing in front of the House of Lords in a tax case, and he was making his submissions. And the presiding Lord said to him, "Well, Lord Advocate, can you just deal with this?" And the Lord Advocate looked at him and said, "Is your Lordship inviting me to depart from my prepared order of submission?" "Well, yes, Lord Advocate." "I decline your Lordship's kind invitation." You need to be quite confident to take that line. If you are the Lord Advocate, you can. Well, having had two distinguished criminal practitioners tell us the story of how to deal with international tribunals from the defence point of view and from the prosecution point of view and from the common law point of view and the civil, we now turn to a more commercial aspect of it. My colleague from Three Verulam Buildings, Jane Evans Davies QC, Davies Evans QC, I'm sorry. Jane is a dual qualified barrister and chartered accountant, but despite that is actually quite witty and entertaining. Her practice at 3VE includes energy disputes, construction and international arbitration, and commercial disputes. She's appointed as lead counsel and as arbitrator in international arbitrations, primarily in the energy, natural resources and infrastructure sectors, with a particular focus on the Middle East, Africa, Asia-Pacific, the Russian Federation, CIS and Latin America. Jane returned to the bar in 2014, having spent many years working for two of the world's leading law firms, Sherman & Sterling LLP and Freshfields Brookhouse Derringer LLP. She's a fellow of the Institute of Chartered Accountants in England and Wales and a fellow of the Chartered Institute of Arbitrators. She was the first chair of the Equal Representation in Arbitration Pledge Bar Subcommittee, a member of the task force which prepared the ICC Guide on Disability Inclusion in International Arbitration, and is the current co-chair of the International Bar Association Subcommittee on Innovation in International Construction Projects. And she's going to talk to us about cross-examination in international commercial arbitration. Jane, over to you.
Thank you, and apologies for being late. I was, as many people are, stuck in the London traffic. It was very interesting hearing Stephen and Leonie speak first, because in fact, while on one view we practice in completely different worlds, it would be fair to say that much, if not most, of what you both said applies equally to international arbitration. Stephen's comment about preparation, preparation is key. In international arbitration, we're often dealing with very technical issues. I'll sometimes be cross-examining the world's leading expert in maybe nuclear fusion, or how do you connect a wind farm to a national grid, or some really complicated things that make you think, I really wish I had paid more attention during physics while I was at school, instead of thinking I'm going to become a lawyer and I will never need to know about this. It was also really true what both of you said about the mixing of different backgrounds from the tribunals. It's very rare that I will appear before three English arbitrators. It's much more common for me maybe to have somebody, in fact I have a hearing next week, I'm appearing in front of a Canadian, an Englishman and a Frenchman. Quite often I'll be appearing in front of maybe someone from Africa, someone from the Middle East, a great mix. And something I would say is I'm very pleased to say that over the last 10 years or so, there actually has been a great improvement in the diversity, not just of where people come from, but also in relation to both gender and ethnicity as well. When I started practicing, it was almost always elderly white males were the arbitrators. That has changed. And with that has changed, I'd say, the dynamic of the tribunals as well. Because something that you're always trying to do is to play to your audience, as it were. You're putting on a show in some respects as a lawyer. And you're needing to make sure that you engage with each of your tribunal, I will almost always appear in front of 3 individuals, and it makes no sense if I only persuade one of them. I have to persuade all 3. So I have to be very aware, where do they come from? What are they expecting? What will they enjoy? What will be persuasive? Also, what will they be uncomfortable with? If you come from a jurisdiction where there isn't the type of quite confrontational cross-examination that you will often see from English barristers, they might feel quite uncomfortable and therefore actually have sympathy for the witness. So you might think, I'm making great headway here, I'm getting lots of concessions. They might be, actually, we didn't like that. So they'll downplay what the witness's evidence that you thought. So it's really important to be aware of that dynamic. Now I have some slides which will hopefully work. Yes. So on this slide, I tried to capture what I would say is the context of cross-examination in international arbitration, as opposed to litigation. And I'm a little wary. I have, of course, Richard sitting here because I haven't done litigation for a very long time. So he might say that I'm being very stereotypical about English high courts and what happens there. But again, for what Leonie said, Leonie may feel very comfortable, actually, in international arbitration because the concept of putting your case doesn't really exist in international arbitration, to the point that when you get an English barrister appearing who maybe is more familiar with litigation and they actively put their case to a witness, you will often see quite a lot of people in the room, myself including, sort of smiling as if they're being somewhat quaint and old-fashioned, because it's not something that we do, or not as directly as you might hear some English barristers doing in court. I'm also very aware of the dynamic of cross-examination, because I think you can sometimes think, this is my opportunity to damage the other side's case. And it's true. A good cross-examination can destroy the other side's case and win the arbitration for you. But I always remind myself, and I remind my juniors, that every question I ask in cross-examination, the other side actually have 3 opportunities to improve their case. Their witness might give a good answer. The fact that I have asked a question means that my opponent can re-examine his witness or her witness in re-examination. So he can go back to that issue and ask another question. He can't lead, although you will find some people who, from some jurisdictions, struggle with that. As I will always object, and the tribunals tend to be quite sensible, and they'll say, we understand people come from different jurisdictions. We will give weight appropriately if they have been led. You can't lead, but you can ask the questions. And the third issue is that if I ask a question, the tribunal will think, this must be an important point, because Mrs. Davies-Evans has asked a question. And so they might ask some questions as well. So I have 1 opportunity for each question to get the hit. They have 3. So I think it's quite important, and you'll maybe see that in arbitration, that quite often people will ask a lot less questions, will have much shorter cross-examination than we would do if we were in court. And another reason why we do this is because we often participate in what are called chess clock arbitrations. Now, I'm old enough that when I started practicing, there was a physical chess clock, and people would press it as you switched from one party to the other. We now have all the juniors sitting there with apps on their phones, but it means that I will be given maybe 15 hours to present my witnesses and to cross-examine the other witnesses. So again, I will have to think very carefully, what is really important? What do I need to achieve from my 15 hours? And how am I going to spend my time? It also means that actually you can get away with cutting off witnesses a lot more in cross-examination than I'm sure Rich would allow me if I appeared in front of him in the High Court, because it's my time. And so if I've got a witness who is deliberately taking their time, not answering the questions, speaking at length unnecessarily, I will be able to say, please stop. You didn't answer my question. It's a yes, no. And I will get away with that much more than I probably would if I was in court. The other thing I'd say, and it's really important, is that more is not better. You will very rarely regret not asking a question. You might regret asking that one question more. So you've got the witness to say exactly what you want on the transcript, and you go for that glory question of, so just to confirm X. And of course they say, no, you must have misunderstood me. So I'm always thinking, do I need to ask that question? And very rarely is more better. If it's on the transcript, the concession you need, move on. And I will often take the view that if my first witness makes the necessary concession, I will never talk about that issue again with another witness, because I don't want to give another witness the opportunity to repair the damage that has been done. And also, as I said about civil law arbitrators, it will depend how experienced they are in international arbitration. If they don't have much experience, they might not like that style. And I think it's something that actually male advocates have to be particularly careful of, in particular when they're cross-examining women, that what might seem a perfectly robust cross-examination can sometimes come across as overly aggressive and a bit bullying if you've got a female witness. And I've certainly seen a lot of arbitrators, in particular some of the more elderly male arbitrators, actually step in and just say this isn't appropriate. I know an arbitrator I know very well said he had watched somebody absolutely demolish a female delay expert in what he thought was a technically perfect cross-examination, went back into the room for the breakout room, and his two co-arbitrators who have civil law background said, we are ignoring what just happened. That is no way to speak to a woman. So you do just really need to watch when you're doing your cross-examination. How well is it being received? If the tribunal is looking uncomfortable, move on, change your style, see how you're going to, what works best. So when I'm planning, as I said, I've got limited time. So I will very much, because I'm doing commercial arbitration, I'm ashamed to say I'm not working in the worthy cases of my fellow panelists. It's all about the money in commercial arbitration. So I will generally be starting with the quantum expert reports and saying, where is the big money? What do I need to attack in the factual evidence or the quantum expert evidence to reduce the money or to build up my claim? So that's what I will be looking at, very much focusing on the money. Also, though, in commercial arbitration, you have to remember you have a client who's paying for this, and it's their arbitration. And quite often, if they've had a lengthy and unpleasant relationship with the other party, there may be some lines of questions they just want you to get. I know a number of clients who say it's the most expensive form of therapy, but for some clients, it's therapy that they're prepared to pay for. So I will always ask my clients, is there something you particularly want me to deal with? Because there might be some point which you say, well, actually, legally, we're not going to win on that. We don't need it. But if they want you to, and it's not going to be damaging, then I normally make sure that I ask that. Now here, what I thought is helpful to understand, and I prepared these tables years ago when I was training some students. I still actually use them at the moment. I've got a hearing next week and I just print them off and look. I'm looking at each different type of witness who I will cross-examine, a witness of fact, a technical expert or a legal expert, and thinking, where are the boxes where I might want to cross-examine? I think it just helps me to think, how am I going to do this? So it's surprising the number of people who exaggerate or sometimes absolutely lie about their professional qualifications. You'd have thought with the internet that people would have realized that you'll get caught out now. But lots of people do that. It's a very easy way to demolish a witness's credibility, in particular if they're an expert, within minutes. And that can help. A very good example I had was a particular gentleman who was appearing as an expert engineer. And when I looked at LinkedIn, which is very much the cross-examiner's friend, I should say, he was clear that, in fact, he appeared to have been practicing as a lawyer for probably 25 years. And I could see he did study engineering at university, but I couldn't find him ever having worked as an engineer. And yet my opponent's entire case rested on his technical assessment of what had happened on the project from an engineering basis. So rather than just saying to him, I knew if I asked him direct, are you an engineer? He would have said yes. So instead, I kind of danced around by working out, I see you do this, I see you do that. A bit of flattery goes a long way. Oh, and you've been speaking here, you've been speaking there, whatever. And eventually, I got him to accept that, well, in fact, it was probably one of the few moments when he told the truth, I think. And I asked him, I said, how long did you actually practice as an engineer? And he said, I think it was 6 weeks, 12 weeks. I cannot repeat what I heard the Australian chair of the panel mutter. I think he meant to mutter under his breath, but I think the entire hearing room heard this. And so I just went, okay, fine. You're here as an expert engineer. But I said, but would it be fair to say you're not an expert engineer at all? You're an expert construction lawyer like me. And he said, yes. I went, fine. Thank you. No further questions. And stopped. And so what would have been a lengthy cross-examination about technical issues ended up being a very short cross-examination about why he had portrayed himself as an expert engineer when in fact he wasn't. And so those sorts of issues work very well in facts, and everything that you both said about inconsistent statements, inconsistent facts, that's what we're looking for, and just being able to peel away and demonstrate that somebody's not credible at all. I have one, and I'll finish with this slide, I think probably, in relation to an expert, because I think cross-examining experts is something that probably terrifies junior advocates and not so junior advocates the most, because in international arbitration you really will get some of the world's leading experts in very complicated issues, and you might sometimes think, how on earth am I going to cross-examine this individual, or how am I going to prepare a cross-examination for the partner who's asked me to do this? And I always remind myself and my juniors of this quote, which is that an expert is one who knows more and more about less and less until they know absolutely everything about nothing. Because it's actually very true, because yes, they might be the world's leading expert and they've got 50 years experience of research and whatever, but in the case, there's probably only one infinitesimally small part of their expertise that you actually have to master. And in fact, you will know far more about the case and the facts than they do. So there's a very small thing. Yes, you will have to get on top of the technical detail. They probably won't be expecting it because a lot of lawyers don't. But if you can manage that very small piece of detail, that will help you to be able to challenge them and get the right concessions that you need. Now, I gave you actually, because I thought it might be interesting, I've also given you the areas to cross-examine a legal expert and a non-legal expert. I thought it might be useful for the students in the room to see. I've also given you just here an example of, we often talk about having scripts. It should say, because I worked in international law firms, we're not old school. I was amused, actually. I saw Stephen's got a few bullets. I'd say it was very old school, and you'll often see the old school barristers, and they'll turn up, and if they've got a yellow sticky with 3 bullet points, that's it. In arbitration, I think we tend to be much more regimented, and we will write lots of scripts and one reason we do that is because we're normally working with very large hearing bundles which are presented electronically. So if you don't know the reference number to your document you want to pull up, it can destroy what would have been your killer line of questioning. So again, preparation, know your documents, know your reference numbers, but also be flexible. So if, as Leonie said, the judge does say, I'd like to hear something else, or maybe the witness gives an answer that you weren't expecting at all, you can say, I'm glad you raised that, because now I'm going to ask you something completely different, and having that flexibility to move around. So with that, I shall stop.
Well, thank you, Jane. Thank you very much. It's been very interesting for me sitting here and listening to those 3 presentations to hear how much actually they have in common between the very different approaches of civil prosecution, common law defence and crime, and international arbitration. I mean, the first and most basic point, you were all told when you did your bar course, proper preparation prevents poor performance. Sometimes there are additional P's put into that, but I shan't repeat it because I'm the treasurer of the inn. But the answer is preparation is the key to everything. It's always the key to effective advocacy. And it involves different aspects depending where you are. Getting on top of the facts so that you know more about the case, you have it at your fingertips. Everyone has a different way of doing it. For me, if I've got 200 lever arch files, whatever else, I reduce it to about half an inch of paper. And I do it online, but I turn it into a piece of paper and cut and paste with the document references and the quotes that I want from the various documents and things like that. And I then color code them to theme them, whatever, so that I don't have to worry about the 200 files or the umpteen gigabits on my computer, whatever else. I've got it there in that note. So if we go off-piste, if it's not what I'm expecting, I've still got my notes, I've got the colour coding, and each one refers to the next place so that I can concentrate on the witness or the people I'm approaching. And expert witnesses, oh yes, always Google them. Look them up on LinkedIn, try and find out. I have one example about 15 years ago now. I was doing awful case for the Central Bank of Ecuador in Nassau. And we had one point about the value of a bank or something, and they called someone whose CV on his witness statement suggested that he was the greatest expert in Ecuador on valuing banks and things like this. And I Googled him and followed up all the links down the bottom. And I found that he was a director of one of the companies of the people I was accusing of fraud. So, of course, once you've got that little thread, and at the end of it, I got him to say, I've come here to try and help my friends, haven't I? And at that point, my opponent pulled his wig over his face. And the judge wasn't really interested, and as Jane said, I sat down. There was no point in going on thereafter. But it does happen. Do it. I mean, it's very important. The other common thread is about knowing your tribunal. In particular, where you're in an international tribunal, where you will not have people whose lives have been spent ploughing the same furrow as you have. You have to be very wary. Again, forgive me for telling war stories. I did an arbitration as a very young silk in Copenhagen, which was governed by Danish law and involved a big Danish company and an Egyptian company, and was nothing to do with English, except that the arbitration agreement said the language of the arbitration was English. And the Danish lawyers wanted someone who was a native English speaker to polish their submissions and things like that. So this was one of those arbitrations which ran and ran. You know, you had a couple of days here and a couple of days there and a couple of days there. And by the time this had been going on for 6 months or so, they said, well, why don't you do some of the advocacy, Richard? I mean, that's your thing. And I made such a mess of it. Not because I didn't do it perfectly well from an English point of view, but because I said, and my learned friend's submission is misconceived. And this was quite unacceptable to the tribunal that I was appearing in front of, because I had identified my opponent with the point, as opposed to making the thing neutral. So I was being rude about my opponents, which was unforgivable. And of course I didn't realise. But now I'm much more careful. You know, once burnt, as it were, you shy away from those things. It's very important to persuade all of the members of the tribunal and to try and get inside their heads and know what will be persuasive for them. And that, I think, is as true in international arbitration as it is in front of international criminal tribunals. Your job is to persuade.
Yes. And the problem you've also got, Richard, that you raised there, which we have at the ICC, we are sometimes dealing with judges of international criminal law who may be diplomats or may have
we haven't even spoken about that yet. Yeah.
backgrounds. And when we were doing the Kenyatta case, we found that particularly challenging as we were making serious submissions on a very important series of matters. And we just felt the tribunal didn't get it. It didn't know what vehicle it was in and meant to be driving. And so it was very, very difficult for us. And we just kept up a strategy of reinforcing our point and giving a month between each bombshell that we were dropping on how bad the case was to drive it home, to hope that someone would have, putting it this way, a word in their shell line. And that was our strategy. Jill Higgins, who's in the audience here, was with me on that. And we used to do it on the Friday at the end of each month for 5 months, drop another bomb, and it would be called that, to drive them to understand what they were looking at.
Do you have this experience, Leonie?
I think there have been some issues more in the past than nowadays on that. I think it's greatly, the majority of judges appointed now are really with a practical background. You still have the differentiation between Group A and Group B in the elections, but the criteria have been elevated. And also the way chambers are put together, whether by strategy or by chance. What I'm observing is that you have a real mix of, and the judges who are presiding over cases, at least in the few years I've been there, they have been real practitioners, persons that have many, many years of experience in their national jurisdictions, which in the international forum, I have to say, is absolutely key. And it's another issue that goes way beyond cross-examination and others, but the senior positions, be it judges or lead counsel from the defense or senior trial lawyers, those that bring experience from their national jurisdictions also have it easier to transition into the international level and act appropriately and effectively in an international setting. In my experience, the learning curve is not so high, even if you have to adapt to a new procedural surrounding. So it doesn't only go for the judges; it also goes for the prosecutors and defense counsel.
I mean, Jane, if you had the experience of appearing in front of arbitral panels where they're not all lawyers.
It's quite often, especially in the construction world and energy, it's quite common to have at least one engineer. And in fact, I've sat on a tribunal where I was the only lawyer and sitting with 2 engineers. And so I find it will depend. You'll often find, I think things like document production and disclosure just go straight over their heads. They're like, what are the lawyers talking about? But when you get into the detail of it, it's really helpful. In fact, it means that you can, you know, and again, you sort of play to your audience. You know that this, if somebody's a particular engineer and they're specialised in a particular area, you will very much speak to them on those particular issues. Or sometimes accountants and economists are quite common as arbitrators as well. And I'd say that most of them try really hard to understand the procedure and what's going on. You will sometimes see the chair having to be a little bit pulling them back on some of their questions, because as arbitrators, you have to be very careful to make sure there's no hint that you might have pre-decided the case before you've heard every last piece of evidence and every last written submission. And so any question that's maybe framed slightly incorrectly or slightly inelegantly might get jumped on as a reason for challenging the award later. And that's why I know you have to be very careful where you've got arbitrators of different jurisdictions who aren't speaking English as their first language, because, for example, they might be trying to put forward a hypothetical and could, would, should. There have been some infamous cases where arbitrators have been challenged because people have said, well, the way they phrased the case suggested they'd already decided something, while in fact it was just someone who wasn't speaking English or the relevant language as their first language and had just slightly got the tense of the verb wrong in that context. So, but it is interesting, and you sometimes get engineers in particular who appear as counsel as well. That can be quite tricky because they'll sometimes, I'm not sure whether they don't know the rules or they take advantage of the fact that they're not a lawyer to not play by the rules. I remember once being asked by the arbitrator who said, in the break, can you go and explain to your opponent how to re-examine? And I walked outside and I said, I assume you know. And he said, of course I do. Because he had just been leading. And, we walked back in and, he carried on leading.
Another good point you make is that your audience is not necessarily only the people you're addressing at the moment. It may also be the transcript. And cross-examination, when you have a transcript, is a different art to cross-examination when you only have the judge making a note. If you want the point that you've made in cross-examination to be in the judge's note, you have to make sure that it has actually got in and been written down. If it's for the transcript, the judge could be asleep at that point. It doesn't matter. You can make it later in your closing submissions. It is there for all time. And it's a different art. And you do sometimes come across people, particularly from the English jurisdiction, who've spent their life in the criminal courts and who are used to the judge's note and not the transcript. Whereas I these days get lost at the commercial court if I don't have a transcript. I forget to make a note because I'm so used to it appearing on the screen as I'm going along. It's a different art, and again, you have to, horses for courses, you have to suit it to that. Well, we'd better get on to the case studies, haven't we? Stephen, do you want to do yours first?
Yeah. So I've already read out to you, and I think you understand the issues in the case of Cermak. And in the cross-examination, the key areas for cross-examination of the military expert was, first of all, and this is the first bit of that clip, the manner of Cermak's appointment out with the military system, which is why I asked the analyst, have you looked at the date? That was their prime document with the indictment. Have you looked at the date? It's the 5th of August. It's the day after Operation Allure had started. So he hadn't mentioned that dimension or aspect or factor in his report. His report was one-sided, that this came from the supreme power, the president, Tudjman. Tudjman had organised Operation Allure at Brioni, and therefore he was the president's man to go and carry out the master plan to attack the Serbian population and commit ethnic cleansing. But my take on it was the reverse of that. And that was that it was outside the system, and actually it was necessary to bring someone in with his background in logistics to develop a very important aspect of getting Knin and its civilian population, which included Serbs and Croats, back to a normal state of life. And then accompanied with that is the command and control. And that's the documents point. What do the documents say? Well, if you've got this guy asking permission to buy a ham to entertain journalists from the military commander, he isn't above him in the rank of things. You build the credible cross-examination by preparation, as we've all said. And there is organisation. I have a roadmap. And the team, Jill understands this, having done many for me, have that roadmap, and it's like that, but it's got the exhibit number and it's diagrammatic. I know what the text is in the story, and I don't need that, but I need the roadmap. And in that clip, you'll hear sotto voce whisper, "Get me the indictment," because I decided to go off the roadmap, and I'm going to put the prosecution's main document, the indictment, I'm going to put the count to their expert and say, does it work? Is this? And he ends up saying no. So their case essentially collapses. Being civil law judges, it was very interesting. They don't like submissions of no case at the end of the prosecution case.
No.
They hate it. And the case was dead and buried, but they want to hear all the evidence. So we had to go through that. And what I did, rather than call all my witnesses and put it to them in direct examination, they have a procedure where you can adopt the statement, very much in civil cases. So and because the judges are very keen to limit defence cross-examination, which sometimes is very unfair, is you've got to build two aspects, your case and challenge. Prosecution's just building a case, and they don't get that because they've had no experience of it. I just got them all to adopt their statements and sat down. The prosecution didn't know what to do. That included the experts and everything. So it was a strategy that saw the case move so quickly they didn't know what had happened. So, but I thought, I'll play your rules back to you. You know, this is what's fair for one is fair to another. It took them by surprise. Sources of evidence, documents, films, reports, that kind of thing is very, very important. But going into the archives, we went to police archives, we went to military archives, and you've got to persuade people to give up these documents. Everyone's frightened. You know, you've just come out of a war. Everybody's frightened. They don't want to be seen helping anybody or taking sides. So you have to get a good facilitator. So we had to get very often a good agent who would help us speak to the police. Come on, help us here. That there's a grave danger of a miscarriage of justice. We need to see those documents. And generally, we succeeded with that. And this is very different from my jurisdiction here. I investigate my cases with my team when we're doing international cases. I don't have that. We will have investigators, we'll have support, but we review all the evidence, we go to the places, we are in control. And that has paid dividends in many occasions. Case of Musama, where we went to the tea factory and found all the original receipts of our client's journeys and where he was, his alibi. Prosecution had been there 3 times, investigating judge had been there 3 times, and no one had ever asked to go to the accounts department. All they were doing was looking around the tea factory and looking for the overalls they wore and guns and machetes or whatever, and the victim scene, you know, where it all took place. No one had really investigated an alibi, and we found that in the accounts department. In fact, it was filmed, files coming off the shelves and us opening them and seeing where he was, petrol receipts, hotel receipts. And the role of military and police experts I've explained enough already. And the cross-examination of non-military witnesses, they will come in with an opinion. And military ones will as well, when they want to see themselves doing as they think the right thing and justice. And that was how we had to cross-examine all these UN witnesses, the UN commander. And the case collapsed around them because they didn't really know what they were talking about, but they had come in with a prepared position. So very, very interesting non-military witnesses. will often have opinions about who is in command or who is responsible, which comes from local folklore or what they've heard or what they've been told. But you've got to treat with great sensitivity people that have been victims and seen the most horrific things happen in front of them. But that's our job, is to get to the truth. So we're both in the same business here of getting to the truth.
Thank you.
Yeah.
Leonie, do you want to
So
talk
I
about your different
also,
approaches?
yes, well, I've also brought a little case study. It's a theoretical example inspired by different types of scenarios that can happen. So a bit of a more complicated prosecution case with an accused that is not the boots on the ground kind of accused, but one more removed, where the allegations go towards a supporting role with contributions, though, to alleged crimes. The prosecution had called a few witnesses that were supportive of its case theory with regard to the role and the contributions of the accused. And they also, in my little example, have some documentary evidence that they believe support not only what the witnesses say, but in the broader sense, the role of this accused, in that he sent emails with certain instructions or requests to the political party through which then crimes were committed. The defense now calls a witness linked to this political party. I'm not going to go into all the details because I assume you have read it. She's a friend of the accused. They go back a long way. She admires him. But she's also an insider of this political party, so she's well versed in the groups at issue in this case, and she provides information through the defense examination that she is well versed in the who's who of the political party and the armed group concerned, that certain meetings that are important for the prosecution were never about arming or financing or any other contributions the accused is accused of, and that she herself was at all the relevant meetings, but basically the accused was nowhere to be found. So I put in two potential approaches for you to think about. And maybe you have some ideas about it. The first approach is really about making use of cross-examination by the prosecution, or maybe even the defense, to gain additional information that may down the road be important for you. Yeah, using the other witness for additional facts. This can be a strategy. It is a risky one. Yeah, but it can be a strategy. So, and it is a judgment call that you have to make on a case-by-case basis when you have heard the direct examination to see whether you risk it or not. But if you risk it, it can be quite fruitful. So it's one option. I put it there with risks involved, but you can actually maybe get additional facts that help your case or where you want to go. The second approach is more of a classic witness destruction type approach. So, emphasizing through questioning that the friendship they have, the closeness of the two, trying to work out more the flaws in her in her character, basically. To put that front and center, so nobody is thinking about her. The judges don't think about her as anybody they can reliably use to refute the prosecution's already established evidence through the other witnesses. So these are the two scenarios I wanted to put to you, and maybe you have some thoughts.
We can think about them, just
Yeah.
because quite a number of our audience, are, at least online, are students. I mean, you're taught at Bar School and with the INS advocacy training that in examination in chief, you never ask leading questions. And in cross-examination, you always ask leading questions. You always ask closed questions, and you never ask a question to which you do not know the answer.
Yes.
But you have to learn how to do that first so that you can do it automatically.
Yeah.
And then you have, as Leonie said, to decide, when am I not going to do that? It's always a risk. Mm-hmm. So asking a question to which you don't know the answer is always a risk. On the other hand, I'm sure it's the experience of everyone on this panel that some of the most devastating questions you ask in cross-examination are simple, open questions. You've led up to it, you've got there, and you just ask the open question and they give you the answer that you want, and that is the most effective. So it's always a risk. You have to choose your moment for it.
If I could just say, I think when choosing your moment as well, it's really important to be looking at all times at the body language of the witness. It's easier when you're in person, because certainly in arbitration now we're quite often remote. But even with remote, you can tell. It's that moment you start seeing people getting flushed. They'll start sort of maybe pulling their collar. They start getting flushed. It'll start here and it will go higher up. They'll maybe cough a bit and having drinks, and sometimes literally start sweating from the top of their head. And at that point, and looking really quite nervous, and you might get to a point in a cross-examination, if you're lucky, or in particular if you're well prepared, where you realise that it doesn't matter what you ask the witness, they're going to agree with you. Even if they absolutely don't agree with you if you asked in any other situation. And you can, at that point, sometimes ask that question. I remember I did once ask someone who had given so much away and was so uncomfortable. And I did eventually say to him, you swore an oath that you would tell the whole truth. What more do you want to tell the tribunal? And he spoke for 5 minutes. I came out and I said to my juniors, just never do that. I just could tell he was about to blab, and he did beautifully. But you do just need to, you can tell when it's going to work and when it's not going to work, I think.
Another thing for the students' body language. Don't forget, it's not only the witness's body language, it's yours too. I was trained as an advocacy trainer by Hampel himself many, many years ago when I was still a junior. And I didn't realise till I was videoed doing cross-examination that when I got to the difficult bits, I hugged myself. I don't do it now. But your own body language, finding a posture where you're relaxed and you are in command physically, is quite important.
And maybe also a body language that doesn't give away your own excitement about what may come next.
Yes, I know. And that can be quite hard.
That's also...
Yeah, absolutely. Jane, do you want to say something about your scenario? I mean, you asked us 3 questions. The interesting one about how you divide your time. Well, that's always... I think you told us that it was the money, yes?
Well, this is, as I said, when you have a chess clock, arbitration, the sort of opening position will be that both parties get equal time, and there will almost always be an argument about whether that's fair or not. You might have only put forward 2 witnesses, the other side sometimes will have put forward, say, 20, and you'll say, well, why should they have equal time to cross mine and theirs? So it will... I could argue this, frankly, either way, depending if I was for the claimant or the respondent. It will depend on the number of people, because even if it's a very bland, short witness cross-examination, the mere fact of getting someone in, it's sort of having those introductory questions, asking a few questions to warm them up before you ask the questions you actually want, that takes time. Also, as the moment you have interpreters, then that can add a huge amount of time. And again, we'll have debates. Is it going to be a consecutive interpretation, which is certainly I prefer. I think it's easier to manage. Or is it going to be at the same time, so you're actually listening with headphones on? I don't really like that, because then you don't really hear the voice of the witness. So I'm not so keen on that. What is preferable, and I'll find a lot of tribunals will say this, they will encourage the witnesses to have an interpreter available, but only to use them if they're getting tired or they want to check some understanding, or what they want to say is a bit complicated and they don't have the skills in English to say that. So you would be using all those types of issues to decide, okay, do I think it should be equal time, or should I get more? My experience is that you need to have a fairly compelling case to persuade the tribunal that it shouldn't be equal time. But translation is probably the one that is most likely to work. Or also sometimes maybe there's an elderly witness who doesn't want to use what we call EPE, electronic presentation, so the presentation on the screen. They would prefer to be shown the hard copies, which makes it much more slower going if they've got the hard copies.
Which slows it down a bit, yes, absolutely. Well, we've reached the point at which we ought to be finishing, but I think we ought to have 10 minutes or so to see if there are any questions. Are there any questions to any of us from anybody in the hall? Yes. Wait for the microphone. If I can ask you, please, not to start your question until you've got the roving microphone, because although we'll hear you, you won't be heard online, and to keep the questions as short as possible.
Good evening. Can you hear me okay?
Yes, thank you.
It's Ian Sheridan from Mountford Chambers. My question concerns how memory loss is treated in cross-examination in the specific context of international criminal tribunals. Briefly, in the civil sphere, in civil court English cases, there was quite recently, in the last 10 years, Justice Leggett in a case called Gestum and Credit Suisse, and he bothered to set out, the learned judge bothered to set out an important point that obviously memory fades over time and that memory can be rewritten. However, I wanted to ask both Stephen and Leonie, in criminal cases, memory is being affected by very traumatic events. How are those discussions played out in terms of cross-examination and the qualities of memory? Thank you.
Yeah, it's a big question, but a very good one. Thank you for that. There's the aspect there's one part of the answer is that we have in cases in the ICC, I'm not sure whether at the ad hoc tribunals have heard experts on the impact of trauma and other developments such as lapse of time on memory. So especially in cases where there is a long lapse of time or other and trauma. This has proved quite helpful and has been accepted in one of the Congo cases. I think it was in Ntaganda. It also fed into the judgment in that case. So when they were addressing certain issues the witnesses had. Now, in actual questioning, at the ICC at least, we don't have a clear, procedure set in stone for prompting a witness's memory with a prior recorded statement. So it has to be done in a specific way. However, practice, at least in the chambers I've been in front of, is more the way I know it also from my home jurisdiction. First, you need to really try to have the witness tell from his own recollection in an open way. Only if that doesn't materialize, but it is actually something that they should be able to remember or that it's very strange, then you briefly ask permission whether you can refresh memory, and then you read a portion of a prior recorded statement and ask the question whether this assists in them remembering, and see what happens then. At some point, you may have to leave it. Yeah. Yeah. And that's my experience. But yeah.
Interesting, because there will always be a statement for a witness in the criminal trial, which would have set out the basis of the evidence. And the judges have been quite liberal at the ad hoc tribunals, I found, in allowing the statements in. And in fact, as I said, and I adopted in the defence case, which took them by surprise, prosecutors were having a statement, calling a witness and sitting down. And then you'd have to get up and cross-examine pretty cold. And then you'd suddenly find that the memory might not have been good, and the statement could have been taken 12 years before, 10 years before. I mean, when you're dealing with the Yugoslavia cases, a lot of the very old statements were still coming up in later trials of, I wasn't in Karadzic, but I know in those Karadzic cases and Mladic cases. So they're pretty liberal about it, but they have their antennae on who took the statement, what the detail was about it in that statement, as there'd been a lot of cross-examination and controversy on the defence side over how some of these statements were taken and whether they'd been led. One witness I had, the paragraphs had been changed by the investigator, and paragraph 32 should have been at 27. But the conclusion that was drawn by 32 coming after 31 led to the witness giving an opinion about Chermakers in that case, actually. And I got the witness to admit that wasn't what he'd said, and they had changed the paragraphs around.
It's a problem. It's a problem in all forms of litigation, international commercial arbitration, and indeed in court. We have a practice direction now in the business and property courts, which talks about you have to explain how the statement has been taken. You mustn't include narratives of what the documents are there. You must only give evidence that the witness could give if giving it by virtue, and you have to say which documents he's looked at to refresh, or she has looked at to refresh their memory. And in international arbitration, it's slightly now creeping in that people will ask the tribunal to make an order in the same form, to restrict the amount of documents coming in. I've seen applications in a couple of arbitrations that I've been in, sitting as an arbitrator, usually with English counsel. It may not be general, but the idea is to try and get over this problem. The other thing, of course, is that although George Leggett in Guestman used his wife's knowledge as a psychiatrist, whatever, to explain all this, the Court of Appeal has got cross with judges who only look at the documents and don't consider all the evidence. So we have fun there. Yes, sorry.
Maybe just one small point, because Stephen Kay just brought that into my back to me. One thing that is completely common in at least Germany, I don't know how it is in the UK, is to call the investigators who interviewed a witness. Now, not as the primary evidence, especially not when you're dealing with a victim of a crime or something. There may never be, it may never be sufficient to call all the investigators, the police officers who conducted the investigation. But it is quite common practice to do that, and to see whether certain gaps can be filled. Now, aside from issues with how the investigator, let's say they worked well and up to standard and conducted themselves properly, there actually shouldn't be a big issue. It is, however, also at the ICC, doesn't seem to be a very widespread practice to do. I've always wondered why we don't do that, but it's not done.
Are there any more questions? Owen.
Thank you very much. I just wanted to say that as a teacher of advocacy for more years than I can remember, I think we should tell our students that they should consider international law advocacy, because after all, English lawyers are really wanted over there in The Hague in one or another, and has been very effective. And the whole business of working out the relationship between the common law advocacy and the civil law advocacy is yet to become at very exciting times, I think. And the other thing I wanted to say was that the Inner Temple especially has been very effective in the kind of teaching of advocacy which is not taught in the civil law as what the Germans would call rhetoric. But we teach it, and the great contribution of Jeffrey Nice and Joanna Corner has been to bring some of us over to The Hague to teach advocacy to people who have no experience of the kind of cross-examination we're used to. And I think that work is going to carry on. And I can see you nodding, Leonie.
Yes, absolutely. I ran out of time earlier, but it is really the Hempel method, the contact with Inner Temple colleagues in The Hague that helped me bridge the gap that I had. Yeah, and it really, absolutely true. So I'm highly thankful, and it's the only association that I have come to know that has this type of effective methodology that you can, as a practitioner from a completely different jurisdiction, relate to, adopt easily. It makes sense. And it works all the time. So, yeah, I'm very thankful for it.
Thank you, Leonie. Are there any more questions? I think we've probably got time for two. Yes.
Just to say, I got back a couple of weeks ago from going to The Hague to teach the teachers to teach Hempel, so we're spreading. But my question is a quick one, and it's in relation to preparation and a fear I always have when preparing cross-examination. I over-prepare. So I grew up doing fraud, which is very document heavy and so on and so forth. It was probably in my nature, but I'm still quite document and witness statement heavy. And I often fear that the result is that my cross-examination is too dry. It's too driven by, well, let's look at this document and that doesn't match with that, and so on and so forth. And I appear in front of different tribunals, juries, tribunals themselves, and also coroners, and so they're all different. But have the panel members found themselves ever wondering, am I being too dry? Am I not telling the story? If so, what have you done about it? Or does that never present itself as a problem to the tribunals you're presenting to?
Jane, let's start with you in answer to this, if we may.
Certainly. Certainly, when I have the time, and because of the chess clock, I don't always, I try to tell the story. So I'm using the cross-examination not just to examine the witness, but to tell the story that I want the tribunal to understand of the case as well, which does take a bit more time. I'll be showing more documents. I'll sometimes see people who are literally just question, and you can see. But then sometimes the tribunal will interrupt and say, "Sorry, just so I understand, what point are you actually making? What bit of your case does this go to?" So I tend to be, I'd say, a bit more of a storyteller. And I think then also you can just try to be engaging when you're doing it. As I say to some students, my cases tend to be frankly dull. Construction is about how quickly can you dig a hole, pour concrete, or weld two bits of metal together. At its heart, it's not the world's most gripping sort of story. And so you have to try to make it interesting, to make it personal, I think. So it's something that I work really hard to do, to build that relationship with the tribunal so that they're actually interested in what often isn't very interesting, but also to build a relationship with the witness you're cross-examining, because I also find they can be quite disarmed in a way, and maybe it's not what they're expecting if at least at the beginning you're sort of quite friendly and have a more of a conversation with them than a traditional cross-examination, because then when you actually ask what you want to, they're more likely to agree. Possibly my favorite cross-examination I ever did, and a very short war story, was I was examining someone who was the CEO of a large energy company, and I Googled him, as you do, and discovered that, oddly, while he used to be the CEO of the company, he now was a Bollywood film director. I don't know why. So I started cross-examining him, and I sort of said, look, actually, I'm really delighted today because I've never met anyone from Bollywood. I love it. I was so excited that you're here in person. Could you just tell me, if I'm just a beginner of Bollywood, what's your recommended first 3 films I should watch? And so he starts talking to me about Bollywood. You could see my client was like, what are we paying you for a chat about Bollywood? And then I sort of said, so, when should we be expecting you to be getting the Oscar for Best Foreign Film? And he sort of was there, he was smiling, whatever. I then asked him the one killer question that I actually needed for him. He was not thinking, he was not, in his head, he was no longer in this very important commercial arbitration. He was standing in Los Angeles with his Oscar. And and I did that. But also the tribunal afterwards said, they said, we enjoyed that so much because they knew exactly what I was doing. He didn't, but it was a way of bringing this little bit of levity to the tribunal, to the proceedings for a short moment. So I will try to have every now and then those little pieces. They're not normally as extreme as that, but frankly, it's good. It lightens the mood. It keeps the tribunal interested, but it also is slightly Machiavellian because it does disarm the witness and they drop their guard and they might tell you something they wouldn't have done otherwise.
Yeah. Well, it's 10:02. I'm afraid we probably better leave it there. Although somehow the Q&A is always the most entertaining bit of the time. Can I, on your behalf, thank our panel, Jane, Stephen, Leonie. They've been wonderfully entertaining and have given us all a lot to think about, me included. We are very grateful to them for giving up their time. May I thank you online and in the hall also for giving up your time to come to this panel, because there's no point in doing it if we don't have an audience, and we've been grateful for your questions. Can I ask you please to complete the short survey which will be circulated by email? We'd like to know your thoughts about the presentations and about the format and the like, so that we can make it better when we do it next time. And can I invite all of those who are here in person, sadly we can't send the wine online, to stay at the reception which we'll have outside. Thank you all very much.
Thank you very much. Thank you.